Votre appel, s'il vous plaît, Monsieur le greffier.
Monsieur Saint-Auguste.
Présent.
Monsieur Saint-Farnham. Madame Le Saint-Ferguson.
If you just wait a moment. Could someone who apparently has their speakers on, microphones on unnecessarily, or loudspeakers, ensure everything's turned off, because we're getting a massive amount of feedback. Thank you. Please carry on, greffier.
Monsieur Le Saint-Lefondre. Madame Le Saint-Valois.
Present.
Madame Le Saint-Meur.
Present.
Monsieur Le Saint-Palais. Monsieur Le Saint-Mezec. Monsieur le Connétable de Saint-Hélier. Madame le Connétable de Saint-Laurent.
Present.
Madame le Connétable de Saint-Sever.
Present.
Monsieur le Connétable de Saint-Prelade.
Présent.
Monsieur le Connétable de Gruville.
Présent.
Monsieur le Connétable de la Trinité.
Présent.
Monsieur le Connétable de Saint-Pierre.
Présent.
Monsieur le Connétable de Sainte-Marie. Monsieur le Connétable de Saint-Ouen.
Présent.
Madame le Connétable de Saint-Martin. Monsieur le Connétable de Saint-Jean.
Présent.
Monsieur le Connétable de Saint-Clément.
Présent.
Madame le Deputy Martin.
Present.
Monsieur le Deputy Southern. Madame le Deputy de Gruville.
Present.
Monsieur le Deputy Lewis.
Présent.
Monsieur le Deputy Tadier.
Présent.
Monsieur le Deputy Higgins.
Présent.
Monsieur le Deputy Masson.
Présent.
Madame le Deputy Pinel.
Present.
Monsieur le Deputy de Saint-Martin.
Présent.
Monsieur le Deputy de Saint-Ouen.
Présent.
Madame le Deputy Doublé.
Present.
Monsieur le Deputy Labbe.
Présent.
Monsieur le Deputy Wickenden.
Présent.
Monsieur le Deputy de Sainte-Marie.
Présent.
Monsieur le Deputy Truscott.
Présent.
Monsieur le Deputy Young.
Présent.
Monsieur le Deputy Ash.
Présent.
Monsieur le Deputy Morel. Monsieur le Deputy Guida.
Présent.
Monsieur le Deputy de Saint-Pierre. Monsieur le Deputy de la Trinité.
Présent.
Monsieur le Deputy de Saint-Jean.
Présent.
Madame le Deputy Lehegra.
Present.
Monsieur le Deputy Aye.
Présent.
Madame le Deputy Pershard.
Present.
Monsieur le Deputy Ward.
Présent.
Madame le Deputy Alves.
Present.
Monsieur le Deputy Pamplin.
Présent.
Madame le Deputy Gardner.
Monsieur le doyen.
Notre aide soit au nom de Dieu qui a fait les cieux et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi le gouvernement et la puissance de la terre, pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, d'unir le cœur et les affections de tous ceux qui la composent, de la conduire tellement toi-même par ton Saint-Esprit, que toute leur délibération est accompagnée de ta bénédiction. Réussisse au bien-être et au soulagement du peuple, qu'il te plut de commettre à leurs soins. Quand nous t'en prions, au nom et par les mérites de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné de t'invoquer en disant, Notre Père, qui es aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite dans la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonne nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous envoie point en tentation, mais délivre-nous du mal. Car à toi est le règne, la puissance et la gloire, au siècle des siècles. Amen.
Monsieur le Saint-Lefondre.
Sir, as members know, the Chief Minister has been unable to return to the island, so may he be marked to faux excuse.
Excusez.
Monsieur le Saint-Palais.
Présent.
Monsieur le Saint-Mezec.
Présent.
Monsieur le Connétable de Sainte-Marie.
Défaut.
Madame le Connétable de Saint-Martin.
Sir. the Connétable of St Martin's is malade.
Je jure que Madame le Connétable de Saint-Martin est tellement indisposée qu'elle ne peut pas assister au test en exposer sa santé. Monsieur le Deputy Southern. Monsieur le Deputy Morel.
Défaut.
Madame le Deputy Gardner.
Malade.
Sir, Deputy Gardner is not only stuck in London but sick.
Je jure que Madame le Deputy Gardner est tellement indisposée qu'elle ne peut pas assister au test en exposer sa santé.
Les états sont constitués. Before continuing with public business as set out in the order paper, I have been asked to permit a statement to be made by the Minister for International Development, and I have allowed that to be lodged and to be made first thing as the first item of business. Minister.
Thank you, sir. I'm not sure if the statement has been distributed to members as yet, and if members would like it in front of them before I deliver.
Right. We don't have a paper copy for distribution. It's been emailed to everyone, so anyone who can find it on their screen. But we're not in a position to distribute a paper copy, having only received it a very short while ago. So, do any members object?
I don't object, so we have the email version. It's a fast-moving situation, and I propose that the Minister continues.
Unless I receive any observations to the contrary. No, then please do continue, Minister.
Thank you, sir. Like all islanders, I've been appalled at the cruelty and violence inflicted on the innocent people of Ukraine by the Russian invasion. Almost 1 million people have now fled their homes, and at least 660,000 have crossed the borders into Hungary, Poland, Romania, Slovakia, and Moldova. The intensifying military assault has resulted in hundreds of civilian deaths, and sadly, more are likely when the Russian attack becomes more brutal in response to Ukraine resistance. We can also expect even more severe destruction to civilian infrastructure and housing. Public service provision such as water, electricity, heating and health is already severely curtailed, and supply chains are likely to be disrupted for a prolonged period of time. At least another 3 million people are likely to become refugees, and the UN estimates that 12 million inside Ukraine will need assistance in the next 3 months. In short, this is an extremely grave humanitarian crisis already, and is likely to deteriorate further. Yesterday, 1st of March, the UN launched 2 emergency appeals requesting US dollars 1.1 billion to assist the neediest 6 million people inside Ukraine for an initial 3 months, and a further 550 million US dollars to help refugees. As Jersey's Minister for International Development, it is my responsibility to ensure that the island provides effective humanitarian assistance to those who need it most, just as others did for us in 1945. We may be small, but even a few pounds can save a life, and furthermore, we can send a signal to our brothers and sisters in Ukraine that yet another country stands with them. To this end, I'm happy to announce that as of late last night, the Jersey Overseas Aid Commissioners have agreed to make initial grants worth 360,000 to be split equally among 3 organisations: the Red Cross, UNHCR, which is the UN's refugee agency, and OCHA, the UN Office for the Coordination of Humanitarian Affairs. Between them, they will provide essential services to the hundreds of thousands who have already sought shelter in neighbouring countries, and the millions still facing terrible hardship in Ukraine. Let me share some more details with you. UNHCR, 120,000. UNHCR estimates that up to 4 million refugees may flee Ukraine. UNHCR coordinates the implementation of Interagency Regional Refugee Response Plan, one of the 2 plans launched yesterday to support governments in their response to a refugee influx through the provision of core relief items. These include shelter, emergency relief items, cash assistance, mental health, and psychosocial support, and helping people with specific needs such as unaccompanied children. Red Cross, 120,000. Both the International Federation of Red Cross and Red Crescent Societies and International Committee of the Red Cross have launched emergency appeals for their operations in Ukraine and neighbouring countries. ICRC response is targeting the support of health facilities, the provision of medical equipment and food, as well as uniting separated families. The IFRC will focus on assisting an initial 2 million people in need, with special focus on vulnerable people, including unaccompanied minors, single women with children, elderly, and people with disabilities. Funds will increase the capacity of Red Cross teams in Ukraine and neighbouring countries. OCHA, 120,000. The Ukraine Humanitarian Fund, the UHF, was established in February 2019 to meet the most critical needs of the conflicted area population of eastern Ukraine. This is one of the worst affected areas in the current conflict and has now suffered 8 years of war. Like other country-based pooled funds, the UHF allows donors to pool their contributions to enable humanitarian partners, such as local relief agencies, to access funds rapidly and deliver timely and coordinated assistance. It will now be greatly scaled up, with others joining us to support it. I'm also delighted that the bailiff has established a dedicated Ukraine appeal, which will enable individuals and businesses to donate funds for Ukraine. The government of Jersey is currently considering whether to add additional funds to this appeal on a match fund basis. However much is raised, Jersey Overseas Aid will ensure this money reaches the right agencies and the right people. Thank you, sir.
Thank you very much, Minister. There now follows a period of 15 minutes for questions to this Minister. Does anyone have any questions? Very well, if there are no questions...
Sir?
I'm sorry, I did need to adjust my glasses, I think, Deputy. Deputy Sir Martin.
Thank you, sir, and I thank the Minister most wholeheartedly for her statement. I was interested, sir, to hear this morning on the radio the Minister for Home Affairs talking about the best way to get assistance to the people who need it most. And I'd just like to ask the Minister, can she confirm that actually sending money to agencies that have direct access to these areas is the best way to do it? I know we all want to do every bit that we can to help, but as the Home Affairs Minister pointed out this morning, transportation of various goods across multiple European countries by truck may not be the easiest way. So can the Minister confirm that cash to agencies that do this work day in and day out is the best way to get funds to those in most need?
I thank the Deputy for his question. In our experience, that is usually the case, to offer cash assistance, even if it enables the recipients to purchase goods in the community. They may be refugees in neighbouring countries, so it also helps those neighbouring countries if the cash is spent in their economy. But yes, in our experience, it has been the most effective way of delivering aid. Although the efforts of the community in sending clothing and other such items, as is happening now, I certainly know in my own parish hall, we've got people are donating whatever they can, a list of things. Those efforts are extremely useful to help the refugees on the ground. But to answer this question, yes, that's our experience.
Supplemental question, Deputy? Deputy Lewis.
Thank you, sir. And I congratulate the Minister, sir, on her prompt action with her team. And yes, I believe this is the correct action to take. As I mentioned yesterday, I congratulate everyone that has gone into collecting all the parish halls, collecting
Deputy, I'm afraid I called upon you, but I wasn't focused on the fact that, of course, you are a minister. And under the normal protocols, ministers do not ask questions of other ministers because they can always find out the answer by a private conversation. Therefore, I'm afraid I can't allow you to continue. It's rightly been brought to my attention, and I apologise for calling upon you.
Fine, fair enough. I could merely congratulate you.
Well, there we are. Senator Mezek.
Thank you, sir. Could I ask the Minister if she's had any conversations with her counterparts in the other Channel Islands, just in case there's an opportunity to coordinate with Guernsey and Alderney, who I understand as well are looking to provide assistance to make sure, as a Channel Island community, we can maximise our efforts and impact?
At this moment in time, no. I know Jersey has a far greater resource for sending funding. Guernsey's is somewhat limited, but as yet, no. But that, I'm sure, will take place in these coming days.
Supplementary, yes, of course.
Thank you, sir. Could I thank the Minister for her answer, and could I encourage her to have those conversations? And I ask that, having myself received a communication from a member of the States of Alderney, who's keen, obviously understanding that proportionately it is likely that Jersey would play the biggest part there, but is interested in making sure that there's maximum impact. So would she agree that it'd be worth having those conversations with her counterparts, not just in Guernsey but in Alderney as well?
Absolutely, sir.
Colin Tarperson, John.
Thank you, sir. Notwithstanding the challenges of getting logistics across to the affected area, would the Minister be able to offer financial assistance to the community that has done such a great job in such a short period of time in collecting so many goods? I visited my parish hall last night. The parish hall is half full. We're expecting more today. They need 13.6 metre trailers. They're going to need some financial help, but also help in connecting them with the agencies that can distribute it. Thank you.
Thank you, sir. It's not usually our experience to logistically get clothing and stuff to affected areas, and I know Jersey Overseas Aid are going to be involved with the Bailiffs Fund in identifying where to send assistance and which agencies are best on the ground to deliver. But using our experience, we are there to help, and we would most certainly look into it because, as the Constable rightly says, we have the experience on the ground and can tap into the agencies who are there already.
Supplemental question, Commentator?
I thank the Minister. Would that offer of help include financial assistance? Thank you.
I can't speak for my other 5 commissioners, and it would be something that we would consider. We will consider everything to deliver aid as best and effectively as we possibly can. I mean, my experience in the past in getting goods to somewhere has been extremely costly, especially the taxes applied here and the logistics, and it can end up a very, very costly exercise. So using that experience, we'll certainly bring that to the table. But like I say, promising cash assistance to enable that to happen, because my aid money has got to be spent overseas, I would have to get advice on that. Thank you, sir.
Very much. Connie Tyler, St Lawrence.
Thank you, sir. Will the Minister advise the Assembly how much she has available in funds for distribution, and whether these are the only funds that are likely to be put towards this humanitarian crisis, or will she be in a position to consider further aid in future as necessary? Thank you, sir.
Out of my pot that I'm allocated at the start of the year, we set aside £3 million for emergency humanitarian aid. We have spent some of that because we feel that spending it at the beginning of the year to help starving children in Yemen, it's no good waiting till December if we can help them in January. So a certain amount of those monies has already been spent. But as I said in my statement, this is an initial response to get monies and aid to the affected people and areas. And we could most certainly look at it again because we still have some monies in the emergency humanitarian pot. It's when we come to the end of the year that we sometimes, if there hasn't been enough emergencies, we sometimes switch the pots. But yeah, we will be looking at it closely, and we'll cross that bridge when we come to it. But this is an initial response, and no doubt this is an ever-changing situation, and we will respond accordingly.
Supplemental question, Connie. Does any other member have a question for the Minister? If no other member has a question for the Minister, then that ends the questions for this Minister following that statement of the Minister. We now return to public business.
So may I raise a quick point? I'm not entirely sure when. It's regards... Sorry, I'm getting used to sitting down. Yesterday,
Is it a point of order?
It
is it something on which you require a ruling from the Chair?
Yes, sir. It's regards Standing Order 65, Part 4B, question without notice from yesterday. An answer was circulated to members, which I'm very grateful for, to the Assistant Minister for SEB. But I believe that the point made in the question regards leave being unpaid was not covered in the email, and it's a very distinct point.
Well, effectively, you're asking whether or not the answer circulated adequately addresses the question, and you're asking for my ruling in that regard.
Yes, sir.
And that's in connection with which question number?
It was a question, if I'm absolutely honest with you, sir, I cannot remember. It was a question asked during follow-up, I believe. Yes, I think we need to have some note of exactly what the question was, exactly what the answer was, so that I can form that view. Otherwise, I'm simply not so there was an email to members from...
Well, I think, Deputy, as I can't deal with it now, and I inevitably will not look at it until the lunch and adjournment,
okay.
If you could provide that information up to the lunch and adjournment, then I'll try and deal with it at that point.
All right, thank you very much.
Thank you very much indeed. Yes, Conito, do you have a point of order or anything?
No, I just wish to respond to the point of order.
No, that's perfectly all right. That's not necessary. Thank you very much indeed. If you wish to deal in the margins of the Assembly with the Deputy, that might be a sensible way of dealing with it, but there's no room for dealing with it within the business of the Assembly. Very well, we come to the next item of public business, which is the draft ecclesiastical legislation consequential amendments Jersey Law P10 lodged by the Chief Minister The main respondent will be the chair of the Corporate Services Scrutiny Panel, and I ask the greffier to read the citation.
Draft Ecclesiastical Legislation Consequential Amendments Jersey Law 2000, a law to amend Jersey legislation consequential on the attachment of Jersey to the Church of England Diocese of Salisbury instead of the Diocese of Winchester.
Yes, Conor.
Thank you, sir. If I could start, sir, by thanking members yesterday for their support, which I'm sure I speak for the Dean as well, is much appreciated. Sir, this law, if passed, would make amendments to Jersey legislation consequential on the attachment of Jersey to the Diocese of Salisbury instead of Winchester. In some cases, this has involved a direct substitution of Salisbury for Winchester, although others, the change has been effected differently as contained in the law. If passed, the Chief Minister would make an order to bring this into force. This law, once it is clear that the order of Her Majesty's Council attaching Jersey to the Diocese of Salisbury has come into force, which it will do upon being registered in the Royal Court. So I move the proposition.
The proposition seconded?
Yes, sir.
Does any member wish to speak on the principles? No member wishes to speak on the principles. Then I ask the greffier to open the voting. Oh, Conor St Brelard, I beg your pardon.
Thank you, sir. If I may refer to the first part with regard to the acquisition of property by the rector. I understand that that will be dealt with by the Dean and not the Bishop of Winchester, or in fact, as it will be Salisbury now. And I just wonder what the motivation behind that was. Thank you, sir.
Does any other member wish to speak on the principles? No other member wish to speak on the principles? Then I close the debate and call upon the Connétable to respond.
Thank you, sir. And I thank the Constable for his question. I'm not particularly cited on the answer, other than to say that if property in Jersey needs to be dealt with, it's perhaps easier if it's dealt with by the Dean, who's resident in the island, than by the Church in the UK. Other than that, I really don't have an answer to that question. So with that, I ask for the appel.
Very well. Appel is called for. I invite members to return to their seats and ask the greffier to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The principles have been adopted. 37 votes pour, 1 vote contre, 1 abstention. Very well.
Sorry, sir. Could we have the abstention? Could we have the two that didn't vote for, please?
The contra and the abstention, yes.
The contra vote was Senator Moore and the abstention was Deputy Pershar.
Thank you very much.
Senators, does your panel wish to call this in?
Yes, sir.
How do you wish to deal with the articles in second reading?
So there are about 5 of them, and whereas I'm happy to go through them, I would hope that the Assembly would wish to take them en bloc.
So you propose them en bloc and you'll answer
yes.
questions on them if need be?
Indeed, sir. Thank you.
Are they seconded en bloc?
Yes, sir.
Does any member wish to speak on the articles or any of them? If no member wishes to speak, then I close the debate and ask the greffier to place wrong system. I invite members to return to their seats and ask the greffier to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The articles have been adopted on second reading. 38 votes pour, 3 abstentions, no votes contre. Do you propose in third reading?
Yes, sir.
Are they seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? If no member wishes to speak in third reading, then I close the debate and invite members to return to their seats and ask the greffier to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The law has been adopted in third reading. 37 votes pour, no votes contre, 2 abstentions.
May I have the 2, please, sir?
Yes. Sorry? I've got 25.
26.
Oh, no, you're right. Sorry, 26. I beg your pardon. It's 38 pour, 2 abstentions. It's contre. Could we have the 2 abstentions, please?
Senator Moore and Deputy Doublé.
Very well, the next item is amendments number 54 to the standing orders, amendments to the Code of Conduct for elected members and related matters P1, lodged by the Privileges and Procedures Committee, and the main respondent will be the Chair of the Corporate Services Scrutiny Panel. There is one amendment also lodged by PPC. You presumably wish to take it as amended.
Yes, please, if the Assembly is in agreement.
Are members content to deal with it as amended?
Yes, sir.
Very well. We will take it as amended. Ask the greffier to read the proposition as amended.
The States are asked to decide whether of opinion to make the following amendments to standing orders of the States of Jersey with immediate effect. Those amendments set out in the amendment paper.
Chair.
Thank you, sir. The committee is bringing forward these proposed changes to standing orders following a review of the Code of Conduct for elected members and associated processes. This review followed a number of recommendations made by the CNAG in her report Anti-Corruption Arrangements, published in January 2021. The review has also considered similar arrangements in other jurisdictions, as well as CPA best practice. I am pleased to be able to present this proposition as amended. The amendments are all in response to feedback from members, particularly following the States members' briefing on the 26th of January. I'm grateful for the engagement from members, as this has enabled us to present a better overall package of changes. I will run through the amendments as set out in the proposition, including the amendments. Dealing first with the Code of Conduct for elected members, paragraph 24 replaces the current set of principles of conduct with up-to-date principles of conduct in public life. The committee considers that this will be a considerable improvement in terms of the clarity of the code. Paragraph 25, which arises from a CNAG recommendation, makes an explicit link between gifts and hospitality and corruption and the perception of corruption. This includes the giving and offer of gifts and hospitality, as well as their acceptance, the receipt or offer of gifts and hospitality to close family members. In this context, gifts and hospitality must be connected to the membership of the states and does not relate to a member receiving gifts in their private lives, unconnected to membership of the states. Paragraphs 20 to 22 also deal with the CNAG recommendations on gifts and hospitality. The key change is the reduction in the threshold above which gifts or hospitality must be registered from 10% of salary to £40, or £100 if more than one gift under £40 is given, received or offered within a 12-month period. This will bring the rules for states members into line with those which already exist for ministers and assistant ministers. Amendment 8 makes clear that these rules do not apply to the Conotabs in respect of parochial duties from which the Conotab does not personally benefit. Paragraphs 26 and 27 are minor tidy-ups. Turning to the registration of interests, paragraph 1, as amended, extends the registration of interests to cover interests held by certain family members. It is important to note that the existing rules already cover shareholdings, land ownership, gifts and hospitality for spouses, civil partners and cohabitees. This is in recognition of the fact that members may be influenced or might be thought to be influenced by interests held by family members. There was some concern from members that the definition was imprecise and unreasonable in requiring published disclosures about family members who were entirely independent of the member. The committee has therefore amended its original suggestion to narrow the definition to encompass dependent children and other family members who are part of the member's household, as well as spouses, civil partners and cohabitees. Amendment 5, which affects paragraph 13, also deals with this point. Importantly, there is a new paragraph in Standing Order 153, which says, in registering an interest held by a relevant person, a member is not required to name the relevant person or to specify the nature of the relationship between the relevant person and the member. When a member is required to register an interest held by a family member, they do not need to specify who the interest relates to protect the privacy of the relative. There are a number of changes to the rules relating to the registration of interests arising from the CNAG's recommendation 7, which suggested that declaration requirements for states members should include disclosure of the value of remuneration from employment or self-employment and the value of land holdings or rental income. The committee had originally proposed to require the amount of remuneration from employment, self-employment or land ownership to be registered if that remuneration was above various thresholds. After consulting with members, the committee has amended P1 of 2022 to reinstate the current provision in Standing Order 152 that elected members are not required to provide information regarding the monetary value of any interest, although they can choose to do so. Instead, members who earn more than 25%, 50% or 75% of their total annual income from external employment, self-employment or land would be required to declare that fact. This would show which areas of earnings were of most significance to members without requiring every aspect of those earnings to be made public. This would be particularly significant for members who have business interests for which registering amounts of earnings could compromise commercial confidentiality. The next change relates to the CNAG's recommendation to introduce an annual review process for the registration of interests. Paragraph 13 proposes that the Greffier will now formally invite members to review their registered interests each year and will be required to notify the Commissioner for Standards of non-compliance with registration requirements in the absence of a reasonable excuse and of potential irregularities in a member's return. In relation to declaration of interests, the committee proposes to replace the notoriously complex Standing Order 106 with simpler text. Two key changes in this regard are to require the bailiff to provide a guide to members and the public as to which interests should be declared. A draft guidance note was circulated to members in January. The other key change is the explicit extension of these declaration requirements to committees and panels. After consulting with members, the committee has further amended the standing order to permit a member with a direct financial interest to contribute to a debate in which they have that interest, but not to vote. The reason behind this is that in such cases, members with the interest are often the most expert or most directly affected by the proposition, and it is unreasonable for the Assembly to deny their right to speak. The next change in paragraphs 2 to 4 relates to suspension of members from the Assembly. The committee proposes to create a new form of suspension, which is suspension as a neutral act, where PPC alone considers that a member should be suspended, but not as a sanction. A member suspended under this new form of suspension would be remunerated and would have access to the State's building, but would not be able to discharge functions as a minister in the Assembly, as a member of a committee or panel, or in any other capacity held by virtue of being a State's member. They would also be unable to lodge a proposition, present a report or comments, or table a question. After consulting with members, the committee has proposed an amendment concerning the proposition lodged by PPC, calling for a member to be suspended as a neutral act, which would now be held in camera due to the likely sensitive nature of the proposition. As well as establishing the different treatment of members suspended as a sanction and as a neutral act, the committee also proposes to end the graduated approach to the suspension of members as a sanction. This would enable a member to be suspended without pay for a first offence during an Assembly term and for longer than the current maximum period for a first suspension of a mere 7 days. 28 days is proposed as the maximum permissible period of suspension. Although these provisions have been rarely used, in the event of a serious breach of the code, the committee considered that the public would be astonished to find that PPC cannot propose the suspension of a first-time offender for more than 7 days and that the member would continue on full pay. To be suspended without full pay, a member must be suspended on 3 separate occasions during an Assembly term, which is very unlikely to occur. Finally, sir, the committee proposes to delete references in standing order to propositions to expel members of the States. It is questionable whether the States has the power to expel a member, given that members swear their oath of office in front of the Royal Court. Although these references to expulsion exist, the committee notes that standing orders do not provide any procedural requirements for an expulsion proposition, such as a certain number of signatures. The committee's view is that members are elected by the people and should be expelled by the people if they so wish. I am happy to answer any questions members may have at the end of the debate. I will accommodate requests for separate votes on separate paragraphs, but bearing in mind that some of the paragraphs are linked. Thank you, sir. I make the proposition.
Right, the proposition seconded.
Yes, sir.
Does any member wish to speak on that? Senator Moore.
Thank you, sir. Just briefly, I wish to thank the Privileges and Procedures Committee and the GREF for the interactions they've had with the Corporate Services panel on this matter. They have thoroughly briefed us and answered our questions, and we were particularly pleased to see the amendment that the Chair brought here, which makes a fundamental difference and meets some concerns that we had, which was about the necessity in the original version to declare income and earnings derived from other sources, which we felt was a step too far. Otherwise, we, of course, understand the importance of bringing these changes forward, particularly in terms of the optics, but also making sure and ensuring that Privileges and Procedures can conduct this oversight role as the public would hope they would if the eventuality arose that there were some irregularities in a member's interests. Thank you.
Thank you very much. Does any other member wish to speak on the proposition? Conor Tarver, St Lawrence.
Thank you, sir. I'd just like to thank PPC for recognising the role of the Constable in dealing with municipality matters and therefore adding section paragraph 4 to section 5, which allows us to not receive hospitality on an ad hoc basis, but it does recognise that we are very often undertaking parochial duties, and on occasion that does mean, sir, that potentially we will go out and have a meal, say, with our roads committee. So when we thank them for the work that they do for us in the parishes. So glad to see that included in this, sir. Thank you.
Very much, Conor Hobbs. Any other member wish to speak on Deputy Higgins?
Thank you, sir. I just want to ask the Chairman some questions regarding suspension of members. Now, we're being told that members can be suspended without pay in various circumstances. And what I would like to ask is, what comparison is done to workers in the public sector? If workers in the public sector are suspended as a neutral act, they are likely paid, and they're paid until the matter is resolved. One of the concerns that we've actually had for quite some time is how, for example, as we've seen recently with health and social services, we've had people suspended for up to 3 years being paid. So I'd like to know, are state members being held to a different standard to that held by the workers in the public sector? Thank you, sir.
Very much. Deputy Southern.
Thank you, sir. I don't expect to be so quick. Before I vote for circumstances in which we suspend members, I would like some explanation of the difference between suspension as a neutral act and as a sanction. And I would like to know under what circumstances would either of those kick in.
Deputy St Martin.
Thank you, sir. There's much good in this, but I have to say to members that I'm uncomfortable about a couple of things. Certainly in my experiences thus far and being a States member, I find it really difficult sometimes when my children, who are grown up and completely independent financially of me, come to me berating me because of the hurdles and hoops they've been asked to jump through by banks because they find themselves politically exposed because of my choice to become a deputy for my parish. And I can't say I'm comfortable about the extension to what is now referred to as a relevant person. It may well be in other, in the UK and larger jurisdictions, the ability not to have to name relevant people is helpful. But in Jersey, sir, we're a very small place where we all know each other, and it won't take much working out if you declare something on behalf of a relevant person, who that relevant person is, so I can't say I'm comfortable about that. The other thing I'd like some clarification on, sir, is the proposer, when she mentioned the percentages of 25, 50 and 75, used the word earnings. But in the proposition, sir, the word income is used, and I'd very much like some clarification as to whether she thinks earnings and income are the same thing. Thank you, sir.
Does any other member wish to speak on the proposition? Deputy Guida.
Yes, sir. This will be at the same time an explanation and a question. When we discussed this in PPC, the the paragraph that I will read, if an elected member total income from any interest declared under this paragraph exceeds 25%, 50% or 75% of their total annual income in the previous 12 months, he or she must register which of these thresholds has been surpassed. So when we discussed this, the intent was actually clearer, and the idea was that we would want to know which industry a member was dependent on. So basically, if 20% of your income comes from hospitality, then you can be seen to have a dependence to that industry. If 75% of your income comes from a different industry, say development, building, then it may be found to be extremely significant to you. And PPC, wisely I think, decided that it was very important for members to declare that and show their dependence to some industries. Unfortunately, I think the paragraph is unclear here by mentioning interest. And interest can be a number of sources, all from the same industry. So it's a completely random example, but somebody with an interest in 10 different bars may have less than 25% income from each of them, but still be extremely linked to that particular business. So it's at the same time to explain the thinking that went into that paragraph and to have the confirmation of the chair that this is the way it has to be understood. Thank you, sir.
Any other member wish to speak? Deputy of St Peter.
So thank you very much. I think Deputy of St Martin raised an interesting point. On paragraph 16 and 15, it would really help to have some sort of tabulated real-life examples about where the thresholds lie. And I'm not asking for it necessarily now, but can it come out as sort of guidelines very soon afterwards? Because Deputy Guida introduced a lot of complexities for some people who may have income from different sources. Do they accrue together to be a 50% or a 75%? Where's the overlaps in that? And I think it'd be really helpful just to have that for absolute clarity. So when we submit accurately and not have the risk of any things going slightly wrong. The other thing, sir, in declarations of interest, there's that lovely word small. Small is can be interpreted differently by very many people, and I'd ask the chair maybe to give us an indication of what small really means. We constantly have the debate with, I never thought I'd mention this, the number of landlords in the Assembly, but then we have had other debates which the bailiff has determined on a small number, and I think there's quite a wide spread there, and I'd like to understand exactly what that is, if I may. But otherwise, I thank the Chair of PPC for coming back with something that is really, how shall I say, is considerably better than the first pass. Thank you, sir.
Deputy Tadier.
Thank you, sir. I've got some questions that I need answering. The Chair will be aware of one that I've raised with her directly. I'm aware that this isn't the pure form of the proposition that she or PPC would have necessarily wanted or initially lodged, but that she's had to put amendments in for pragmatic reasons. So one of the questions relates to the percentage of income, and it seems to me that that doesn't tell the full story, because of course there are members in the Assembly who rely and survive solely on their states members' income. There are others who may have some small additional incomes, such as, I don't know, playing in a band, or they may have some pension income, which might be more substantial. They might have investment income. And then there are other people at the other end who are multi-millionaires, who have lots and lots of properties, and who, I think we'll leave it at that. So having a percentage doesn't actually tell you the full story, because if somebody gains 50% of their income from property, income, etc., it doesn't actually tell you what the overall income is. So I'm wondering whether actual figures would have been better, but I know that there were concerns about commercial interest that are shared by hopefully a small minority of the Assembly. The other concerns I have are to do with suspensions. I believe that in the past we've seen suspensions from the Assembly used as a political weapon against a previous member who's no longer in the Assembly. And even if that weren't the case, we have to be very mindful of making sure that there is no mechanism for an Assembly that might be led astray. And we know that the Assembly has been led astray in the past. We know that the Committee of Inquiry told us that a former minister lied to the Assembly, and that he lied in an Assembly sitting which was in camera, which was perhaps even worse, because there was no accountability, and that the said minister then lied to committee of inquiry, sir. That's all a matter of public record. And what concerns me, therefore, is that we're being told that a member can be suspended, possibly have their pay docked or removed completely, albeit on the third suspension. And there is a general principle that one is innocent until proven guilty. And that needs to be fundamental, sir. And so there's a difference between someone being removed from office because they've committed an offence which is no longer compatible with the role that they hold, or something that simply hasn't been proven, which is being investigated, sir. I'm also very uncomfortable that any debate should take place in camera, because the public forum which we have here should always give the default that it is open to scrutiny and accountability from the public, sir. And if we start having debates, and of course these things are always theoretical and hypothetical until they actually happen, if we have that kind of scenario where the decisions that are being made behind closed doors, and they could be ostensibly for very good reasons to protect sensitive information, we leave ourselves open to the finger being pointed at us that decisions are being made and there's a Canada report that is taking place there. So I'd like clarification from the Chair on those particular issues before deciding whether I think I can support the principles, but it's ultimately some of the fine detail to do with those points. Thank you.
Thank you very much. Does any other member wish to speak on the proposition? Colin Tarverson, one. Yes. No. Might have been the reason, but who knows?
Thank you, sir. Well, if it is the case, I present my apologies. So I rise to speak in response to a point that the Deputy of St Martin's raised. But before I do, I'd just like to congratulate the Chair of PPC and the committee on listening to members' concerns and making adjustments to the regulations, which in my own view, and whilst it won't affect me because I won't be in the next Assembly, make them substantially more acceptable. But I'd just like to pick up on the point about politically exposed persons. With the greatest respect to PPC, that isn't within their gift. It's a decision that's made by our anti-money laundering legislation, and as such, financial institutions in the island are required to enforce that legislation and demand certain additional requirements from politically exposed persons and their connected families. And with the best will in the world, PPC has no control over that. I'm sure they'd like to have those removed, but unfortunately I can't see that any of the major financial institutions are going to listen to us. So sadly, as members, we all have to go through this, and at times I agree with the Deputy of St Martin's, it can be painful, but as we've seen with recent events, these regulations are entirely necessary, and we need to, as banking institutions and financial institutions, need to understand exactly who they're doing business with, and that includes us, unfortunately. So I hope that's addressed that point of the Assembly, and I'll leave it there, sir. Thank you.
Very much. So, yes, before I call on Deputy Ward, who's next to speak, just mention that if any members are going to ask for particular parts of the proposition to be taken separately, if they can indicate a little bit in advance so that the greffier can attempt to work out what the effect of being taken separately has on other parts of the proposition. This is obviously a single vote. There's no vote on the principles because it's an amendment to standing orders. So there'll just be a single vote on whether it's accepted or not. But the Chair, of course, has indicated she would take certain parts separately if requested. Yes, Deputy Ward.
Thank you, sir. A few things. First of all, I'd like to thank the Constable St Warren for raising a point that I was unclear about. I'm pretty sure that the politically exposed person was due to other reasons, and thank you, that's cleared that up, so I don't have to raise that one. There's just a couple of things, and forgive me, I asked Chair of PPC to forgive me, sir, if this is somewhere in this document or in a linked document. But it's just the notion of a dependent child. Is that dependent in terms of the age of that child as in terms of social security dependence, which I believe is 25, or is it whether they have their own income, pay their own tax, for example, and the definition of that for this, because it needs to be clear. And also in the same way, the member of a household, Is that somebody who habits the household for a particular time? Someone who has children who are moving away, and perhaps one day they might both move away and be independent in that way, then it does change what you're declaring. And I wouldn't want to make a mistake because I simply haven't got the definition clear. I understand why, on another note, the percentage was changed to some extent, but I do somewhat share Deputy Tallier's concern that figures aren't there because we need to get some idea of quantity. I think that's important in transparency in terms of where we are. However, I understand why that has to happen. It is a step forward. There is a point in this, and I've been scrolling through it, and of course I've now lost the part that I was going to talk about, that is, refers to the greffier, I believe, having to get states members yearly to address their declarations. Now, I would welcome that, but what I would like to know is, and I would welcome, is a formal notification of that and a formal meeting to go through that yearly, so that we are absolutely clear as to what we're doing. What tends to happen, for example, with data protection, is sent an email, and that's been very helpful to say your data protection is up to date or not, and that's really, really helpful because time flies by before you're knowing it, and there's a lot going on, and we don't have personal secretaries to help us out. So there are, and I think that is an issue. Until there is that direct support from members for these things, we have to be very careful, and it has to be recognised that there may be mistakes made early on. So I welcome this, and I would like to see it forward, but there was just a couple of questions there which hopefully are easy to answer. Thank you, sir.
Thank you very much indeed. Does any other member wish to speak on the proposition? Deputy Martin.
Yes, and hopefully I think I know the answer, but I just want it completely clear in my mind before I vote on the Amendment 1, and where it says members of the household who are part of the household. So the scenario I would give is you move in because of circumstances, an elderly parent who is receiving care from you because that's how they live. And this, I want the deputy to tell me this wouldn't prevent the member wanting to move in with their family or the family wanting them to move in because of the information that might be asked of the sitting states member that would have to go on this form. I think that's what it's saying, and I am still concerned about that. But I'll wait till the deputy obviously sums up before I make my decision. But I do think if it is that so, I do think it could be a step too far because you're doing one thing for one reason, but then you, as the deputy of St Martin says, we live in a goldfish bowl in Jersey. You know who the parent or the step parent is who's moving in, etc., and it blurs the lines of who has what and could you be influenced. I would say most people, I'd say all of us wouldn't and shouldn't be influenced. But I don't think this is clear enough, so I'll wait to hear the deputy summing up. Thank you, sir.
Thank you, Deputy. Does any other member wish to speak on the proposition? No other member wishes to speak on the proposition? Senator Mezek.
Thank you, sir. I had been looking forward to this debate, but it's turned out to be quite clinical in the approach that members have taken in terms of the questions they've asked, less so on the principle behind what we're doing, which I suppose is actually probably a good thing, and hopefully it's a sign of broad agreement on the principle that the direction that PPC is trying to take this Assembly is absolutely the right one, and for that reason I'm absolutely delighted to vote for every single part of it. I'd have probably have been even happier to have voted for it unamended, but I totally understand why the amendments have been made, and they still help take the Assembly in that right direction. Ultimately, this is about providing greater transparency and accountability for the elected representatives of the island, which is something that I think the public would value, and something which I think many of them may be mortified if there were attempts to scale back some of what is proposed. So I wanted to add my words of congratulations to PPC for getting some of this done. When I served on PPC in the previous electoral term, I had raised some concerns about the transparency of the declarations of interest that states members have to fill in that didn't require us to be clearer about what certain business interests were so that the public could proactively investigate that rather than what I think is actually quite an unsatisfactory system where many of these interests, the details of them, only get recorded in Hansard as and when a debate comes up, which is much harder for the public to go back and research and see who had declared what and what that actually meant. So this new system meets much better democratic standards, and I'll be very pleased to vote for all parts of it, take us in that direction.
Does any other member wish to speak on the proposition? No other member wishes to speak? And I close the debate and call upon the Chair of PPC to respond.
Thank you, sir, and I'd like to thank all members for their contributions and their queries. I'm going to try and address these in order that they came up because that's how I've written my notes. I'd just like to start off by thanking Senator Moore and the Constable of St Lawrence for their comments and also the Constable of St Juan for explaining politically exposed person's status. So Deputy Higgins highlighted whether we were being held to a different standard to our own employees. So it's much the same, our employees is much the same to this proposal. So members would be suspended on full pay, but obviously this would be subject to an Assembly's decision. So it could change depending on the severity of the suspension, which actually follows on to Deputy Southern's question around sanctions. It is stated in the report, and it does say that a neutral act would be, for example, if a member is being investigated for a criminal offence or facing trial, whereas a sanction would be when the member is found to contravene the Code of Conduct and there has been an investigation by the Commissioner for Standards. Deputy of St Martin, I understand his concerns. We have changed what is meant by relevant people so that it is defined as dependent children and relevant people in a household, plus spouses, etc. But I can understand that obviously living on a small island, there's only so much you can do, I guess. The Deputy of St Martin also raised the concern about the wording, earnings and income. It is income from employment, self-employment or land. The Deputy Guida, I'd like to thank him for assisting as well. It would, just to clarify, it would be 25% from employment, not from individual industries, unless all the sources of income were from the same industry. So in this case, in his case, you'd have to declare more than, for example, more than 25% from self-employment. As a bar owner, it would be specifying the income from each bar, if that makes sense. The Deputy of St Peter, happy to provide further guidance. However, it is in the bailiff's guidance, and it is ultimately up to the bailiff to determine what is meant by small. Deputy Tadia covered quite a lot. So pension income doesn't need to be registered, nor does investment income. He was correct regarding the suspension must follow on from a Commissioner's report, and also all safeguards in the Commissioner's law and standing orders, and we've put a 28-day cap on the length of suspension. I think he makes a fair point regarding the in-camera debate, but the amendment has been adopted now. Deputy Ward, dependent means that the child depends on the parent to live. So it's not necessarily tied to an age. It is around about whether that child is actually fully dependent on that parent to live or not financially, and everything. And with regards to a member of the household, this means somebody who lives with you. It doesn't mean somebody who's living with you for a couple of weeks, for example, but if someone lives with you for, say, 6 months, it's probably worth regarding them as a relevant person. And also, just to address Deputy Martin's point as well, if you move in with an elderly parent, they do then become part of your household. So people would expect a member, well, they would expect possibly that a member might be influenced by the land or etc. that elderly parent might earn if they actually live with you. But obviously this is about interests that you know, and if you don't know what shares your elderly parent owns, then you can't declare them. And it is only significant shareholdings, land and gifts received in relation to being a states member. It's not about income, pensions, dividend income, etc. Obviously, if you have a house with a granny annex, for example, and the elderly person lives independently, but you pop in and help out, that's not your household. It's a next door property you may well own. So I hope that's clarified everybody's questions. Obviously, if PPC are more than happy to provide more guidance, the Greffier are also very happy to have formal meetings with any member who would like to go through these things in order to make sure that their declarations are fully transparent and they haven't fallen foul of any issues. So please do feel free to ask and approach PPC or the Greffier. And with that said, I maintain the proposition and call for the appel. Thank you.
Very much. Now, Deputy Tadier asks if you'll give way for a point of clarification, Chair.
Yes, sir.
Deputy.
Thank you, sir. It was on the point of the in-camera sessions for debating a suspension. The chair said that had already been amended. What does she mean by that? She's saying that's already what we do rather than what this amendment is seeking to change.
Thank you very much, Deputy. Yes.
Yes, sorry, sir. So the original proposition didn't include that option for in-camera, but the amendment that we've put in, and obviously this has been read as amendment, now incorporates that in-camera option. Thank you, sir.
And will you give way to yes, Deputy
Can I
Tadier?
seek clarification on that? Because that's exactly the point I was making, which I don't think the chair addressed, is that I have trouble with an in-camera debate for probably most things, but certainly for suspensions. And can she justify why it's been put in here?
Okay, so it was put in following feedback from members at the briefing that we had in January. I believe it was possibly, I'm not sure, I can't remember who it was, but it was about around the possible sensitivity of the situation that could be discussed in this proposition, and I think we have to be sensitive to members in that way.
Will you give way to a further point of clarification from Deputy Higgins, Chair?
Yes, sir.
Deputy Higgins.
Thank you, sir. The Chairman did give an answer. I just want to ask her to repeat it because I want to be absolutely certain about what she's actually saying. Is she saying that with suspension and, for example, any other aspect of that, are we being treated in exactly the same way as the public sector, or are there any differences either beneficial to us or to our detriment compared to the others? Are we being treated on the same basis? Thank you.
Well, members aren't employees, and essentially it comes down to obviously what happens within that debate. So we could follow, for example, the same way that that our employees are treated in that scenario. However, the outcome of a debate might be something else. So we have to be adaptable, but also, we aren't employees.
Do you have a point of clarification, Deputy Pamplin?
No, it's to ask to raise the defer on Deputy Morel, sir, for the vote.
Yes, will members agree? I'm sure. Yes, defo is raised. Yes, we now come to the vote. Chair, are you content that the issues raised in the chat be taken separately, specifically the... sorry? Oh, you can't see the chat. Well, I should tell you then.
As long as it's, I can't see the chat, but as long as it's doable, that's absolutely fine.
Right, very, very well. Well, what we propose then is that we take paragraphs 4 of the amended proposition and 14 together. Right, Constable St Mary. Before I proceed with this, the Connétable of St Mary wishes to join online, but at the moment, of course, he's on default. So would anyone propose the raising of the default on the Constable of...
Yes.
Very well. Members agree. Yes, because until we do that, we can't actually permit him to join the meeting. So very well. Well, what we'll be doing then is we'll be voting on paragraphs 1, 2 and 3 firstly, then 4 and 14 together, then the remaining paragraphs 5 through to the end, with the exception of 14, which will already have been voted on. 4 and 14 are taken together because they have to stand together, and they deal also with the in-camera question as well as the suspension of members question, which have been asked to be taken separately. Very well. Well, the first vote then is on paragraphs 1, 2 and 3 of the amended proposition. I invite members to return to their seats, and I ask the greffier to open the voting.
Is that approval from John Young? I think. Yeah.
If members have had the opportunity of casting their votes, then I ask the greffier to close the voting.
For 13. 12, 13. Yep. 13 per, but the Constable St Mary was too late.
Too late. Very well. The proposition 1, 2 and 3 have been adopted. 40 votes pour, no votes contre, 1 abstention. We now deal with 4 and 14, which are linked.
Can we have the abstention, please, sir?
The abstention was Deputy Martin.
I think, sir, I think that's it. It should be the deputy for St Martin, or of St Martin was the abstention.
I'm sorry, it probably was the Deputy of St Martin. I'm doing too many things at once.
Well, there we are. We come now to paragraphs 4 and 14 to be taken together. I ask the greffier to open the voting. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The 4 and 14 have been adopted. 40 votes pour, 4 votes contre, no abstention. We come on to the remainder of the paragraphs. And I ask the greffier to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The remaining paragraphs have been adopted, 41 votes pour, and no votes contre, 2 abstentions.
May we have the two, please, sir?
The two were the Deputy of St Martin and Deputy Tadier.
The next item of public business was to have been the draft criminal procedure consequential amendments, but that has been deferred by the Minister. So we now come on to draft public holidays and bank holidays amendment number 4 Jersey Act P5. The main respondent was the chair of the Corporate Services Scrutiny Panel, and I ask the greffier to read the citation.
Draft Public Holidays and Bank Holidays Amendment number 4 Jersey Act 2000. The states make this act under Article 2 of the Public Holidays and Bank Holidays Jersey Law 1951.
Thank you, sir.
Deputy Minister, yes.
Thank you, sir. It's a privilege for me to bring this proposition before the Assembly today. I know that all members will join me in recognising Her Majesty's historic milestone of 70 years on the throne, something never before reached by a British monarch. Over her 7 decades of dedicated public service, the Queen has been a true inspiration to islanders and the wider Commonwealth family. During her reign, the Queen has overseen 13 Lieutenant Governors, 9 bailiffs, and it says 4 Chief Ministers, sir, but of course, presidents of P&R committees who preceded the Chief Ministers as well, sir. Her Majesty we've been fortunate to welcome Her Majesty to Jersey on 6 separate occasions, first as Princess in 1949, and more recently in 2005 to celebrate 60 years since our island's liberation. This Act proposes to create a special one-off bank holiday weekend from the 2nd to the 5th of June to commemorate her Platinum Jubilee. This is, of course, in keeping with the arrangement planned both in the United Kingdom and in our sister island of Guernsey. Members will be aware that the Bailiffs' Chambers have led on arranging an impressive schedule of events to commemorate Her Majesty's Jubilee throughout this year, including celebrations over the proposed bank holiday weekend. So this Act serves to facilitate the festivities planned for this summer, and I hope members will join me in paying tribute to you and your staff, sir, for the work that's been done. And excuse me, sir, I've been running up and down the stairs. Thank you, sir.
Very much. Is the proposition seconded?
Yes, sir.
Does any member wish to speak on it? Arbus and Brulach.
Thank you, sir. And whilst not standing to be unsupportive of the proposition, could the Miss Minister or the Assistant Chief Minister please elaborate whether the 1.38 million cost per day incorporates the overtime necessary to the people such as nursing staff and care staff have to be paid to cover the time, overtime rates and so on. And is there an estimated cost to the private sector of such a bank holiday, once again, particularly in the light of care homes and so on, who will have to pay overtime rates? Thank you very much.
Deputy Tadier?
Thanks, sir. I think I can answer the question of the Constable of St Brelard, because in 2019 the Council of Ministers did issue a comments paper when another states member was asking for a one-off bank holiday. Exactly what we're doing here today. And they put comments in to that proposal which members supported. So the members supported the additional bank holiday, but the Council of Ministers didn't support the additional bank holiday, which was for the corn riots last year, which I know that many thousands of islanders enjoyed, and which I know that the St Helier parish sponsored very heavily, and it was a great event which I think saw coming together of various organisations to make it a great day. And I know that that's also what will happen for this very special occasion that Senator Farnham is not only supporting but is directly sponsoring in his department. It's quite right that we do remember this momentous occasion. But it's strange, isn't it, that the maths and the arguments can be different depending on what the reason is for the bank holiday. So to answer the Constable of St Brelard's question more directly, I'll read from those comments of the Council of Ministers. They say, returning to the subject of the bank holiday, it is important not to underestimate the impact of an extra day off on Jersey's wider economic health. Businesses would still have to pay wages and salaries, but would lose one day's worth of revenue. Even if the business remains open, staff would be entitled to a compulsory day off at another time if they work on a bank holiday. In terms of government and non-ministerial departments, the cost of paying staff who would otherwise have worked is estimated to be 1.38 million. Remember, these are figures from 2019. This is not an additional cost to government, however, it does reflect the cost of a day's lost work. That work would either have to be covered by overtime payments not done or added to the employee's workload when they return to work. A detailed analysis by the government has produced the following. Estimated cost of unworked salary payments, £1.374 million. Estimated cost of additional shift payment rates, £115,000. Estimated total cost, in inverted commas, of bank holiday to the Government of Jersey, it's £1.5 million. They do go on to say that it's difficult to reach a definitive figure for overall impact potentially incurred across the community for the bank holiday. They talk about night shifts. They say that the Jersey Chamber of Commerce is particularly concerned about the effect on small businesses and those experiencing difficulties. It has estimated that each day could cost the economy up to £10 million in lost wages and productivity. Based on average GVA per working day, minus property rental, it is also estimated by the government economists that in the worst case scenario, a bank holiday could cost £18 million. But that's okay, because that's only when it's a corn riots bank holiday, when it celebrates a particular event that they don't want to celebrate. But when it's an event which is a monarchist bank holiday, we don't get all those objections. So that's okay. We can support this today in full knowledge that everything is going to be great and dandy.
Connie Thompson-Lawrence.
Thank you, sir. I'm not sure, having listened to what Deputy Tadier had to say, whether he will be supporting this when we come to the vote. But I am certain, sir, that it will be approved by the Assembly today. However, that, I think, puts us in a somewhat invidious position because all of the celebrations have already been arranged and organised, not least, sir, by your chambers. So my question to the Deputy Chief Minister is, as the UK and Guernsey approved this bank holiday weekend or this extra bank holiday some months ago, why has it taken us so long, or why has it taken the Council of Ministers so long to bring this to the States for approval, sir. Thank you.
Does any other member wish to speak on Senator Mezek?
Thank you, sir. Briefly, and to develop on some of the points that were raised by Deputy Tadyer, I'm obviously absolutely 100% in support of this, and I'm also certain that the Assembly will adopt it. It's the right thing to do. But it was noticeable, the difference in the tone in the financial and manpower implications compared to previous attempts to establish either one-off bank holidays in Jersey or other arrangements. And I know that because it was one of the first propositions that I brought to the Assembly when I was first elected, was to try to get some provision in place so that when Liberation Day falls on a weekend, that there is a compensatory bank holiday provided at another time. And I have had the argument put to me we couldn't possibly do that because of the cost of the economy that there would be. So I was pleased when the Corn Riots bank holiday was approved, despite official Council Minister's objections, and I'm pleased that this proposition comes through with a slightly different tone in the report to it. And so I guess I kind of wanted to exploit this opportunity in the debate on it to say that perhaps as an island we ought to have a little bit of a think about how we arrange bank holidays here, because it is the case that compared to lots of other jurisdictions, we don't have as many bank holidays or public holidays, and they are an important and useful way of bringing people together if they're being held for a particular reason. And there's no doubt that this particular occasion, I'm sure, will be wonderful and will bring people out to enjoy themselves and spend time with other people. The Corn Riots was a great bank holiday, and the events that were held across the island, the walk from Trinity Church to town, the event in the Royal Square, all of that was fantastic. And I think it would be a good idea for us to have a think about how we can do some more of that. And this proposition has provided a very a nice shift in tone that would enable us to have that debate. And if I were being slightly cheeky, I might suggest that the 16th of July, St Helier Day, would be a good opportunity for that. And if some members object, then perhaps we could make it just for St Helier residents instead. But I'm, of course, just being flippant there, sir. But I, of course, support the proposition.
Very much indeed. Deputy Masson.
Yes, thank you, sir. And I have to chuckle, but I fully support Senator Mezek's suggestion of the 16th of July being a bank holiday, and that has nothing to do with the fact that this is also my birthday. Thank you, sir.
Thank you very much indeed, Deputy Edding. Does any other member wish to speak on the proposition? If no other member wishes to speak on the proposition, then I close the debate and call upon the Deputy Chief Minister to respond.
Thank you, sir, and my breath now is fully restored. The Constable of St Brelard's a question I think was partially answered by Deputy Tadyer, but if we want to, I can't provide a drill down into the costs and the figures if that's what the Connotar was asking for. But we do know there is a cost to business of holding a bank holiday. We tend to only bring proposals for such on special occasions, such as coronation of the 70th anniversary of the Majesty of the Queen, the Reform Day proposition, because increasing the number of bank holidays we have on an annual basis, so if they're recurring, then poses a more serious questions on the cost of business. But I'm sure the Assembly will fully support one-off bank holidays for special occasions, although I think declaring one for Deputy Masson's birthday, so there might just be stretching the envelope a little bit, but I'm sure we can discuss that behind the scenes. On the positive side, sir, on occasions like this where we celebrate a joyous occasion, the costs for some businesses are clearly offset by the trading advantages. Many businesses in the island, while some will close and incur additional costs, and many will see benefits from an increase from businesses, islanders and visitors enjoy themselves and get out into the community. And, of course, spend money, sir, to celebrate the wonderful achievement of Her Majesty. I'm sorry, I cannot answer so as to why this proposition wasn't lodged earlier. We don't ever wish to preempt the decision of the Assembly. It would have been, of course, more sensible to get this approved before agreeing the schedule of events, but on this occasion it hasn't happened so, and if the states were not to approve this today, then we would simply have to revisit the schedule and adjust it accordingly. But I very much hope it won't come to that, sir, so I hope members will forgive us for that oversight, sir, and with that I make the proposition. Thank you.
Thank you very much, Senator. I invite members to return to their seats. And I ask the greffier to open the voting. Members have had the opportunity of casting their votes. I ask the greffier to close the voting. Deputy Pershard appears to have sought to vote twice. So, notwithstanding the fact that someone in the chat has actually voted pout, I will take that as a pour vote, and the proposition has been adopted at 44 votes pour, no votes contre, no abstentions. The next item of public business is the draft Marriage and Civil Status Amendment Number 5 Jersey Law, P6, lodged by the Minister for Home Affairs. The main respondent is the Chair of the Children, Education and Home Affairs Scrutiny Panel, and I ask the greffier to read the citation.
Draft Marriage and Civil Status Amendment Number 5 Jersey Law 2000, a law to amend further the Marriage and Civil Status Jersey Law 2001 and for connected purposes. The states, subject to the sanction of Her Most Excellent Majesty and Council, have adopted the following law.
Minister.
Sir, well, I will apologise again to the Assembly for presenting a very, very long law and just as long speech, but at least this one is actually quite interesting. The two draft laws, P6 and P7, being brought before the Assembly, should be treated as siblings, as they both contain a number of interdependent provisions that operate for both marriage and civil partnerships. An example is a new provision for an expanded scheme of authorization for civil celebrants, which has been expanded to include civil partnerships, but is found in the proposed amendments to the Marriage and Civil Status Jersey Law 2001. In February 2018, this Assembly debated and voted in favour of the draft Marriage and Civil Status Amendment Number 4 Jersey Law 2018 that provided for a number of amendments and improvements to the 2001 law, including allowing same-sex couples to get married in Jersey, allowing for the solemnization of marriage in the open air, including in public spaces, streamlining the processes associated with giving notice to marry and the registration of marriage, introducing additional safeguarding requirements to better protect against sham or forced marriage, and making new necessary provisions in relation to marriage in emergency or special circumstances. The draft Marriage and Civil Status Amendment Number 4 Jersey Law 2018 did not, however, make any further amendments to reflect the requirements of the United Nations Convention on the Rights of the Child, the Convention on the Elimination of All Forms of Discrimination Against Women, or the independent Jersey Care Inquiry results. Amendments to the 2001 law and the Civil Partnership Jersey Law 2012 to further the compliance with the UNCRC, CEDAW, and IJCI are made by this draft law and the Civil Partnership Amendment Jersey Law 2020 something. The draft Marriage and Civil Status Amendment number 5, Jersey Law, is broad in its effect. I will only touch on the main topics contained within the draft law. The first item that this law will address is age of marriage. The UK's ratification of the UNCRC was extended to Jersey in 2014. As part of the state party to the UNCRC, this island is subject to the monitoring and reporting processes of the UN Committee on the Rights of the Child. And we have an obligation to continue to pursue measures to realize children's rights and implement the convention. In June 2016, the UN Committee on the Rights of the Child recommended in their 5th periodic review of the UK, including Jersey's compliance with the convention, that the state party raised the minimum age of marriage to 18 years across all devolved administrations, overseas territories, and crown dependencies. The committee had expressed concerns about systems which potentially allow for the marriage of girls and boys aged 16 or 70 years old. The UK's ratification of CEDAW was extended to Jersey in February 2021, and as such, this island has an obligation to continue to pursue measures to further realize the rights of women and girls. The CEDAW Committee's General Comment 21 explicitly states that the committee considers that the minimum age for marriage should be 18 years for both man and woman. A public consultation also asked if Jersey's laws should be amended to raise the minimum age of marriage and civil partnership to 18 years old. 77% of respondents agreed, 13% disagreed, and 10% said they had no preference. I propose, as part of the effects of this draft law, to raise the minimum age of marriage to 18 years of age. I also propose to introduce similar amendments as part of the Civil Partnership Amendment Law 2020 to, hopefully, to raise the minimum age of civil partnership to 18. As part of raising the minimum age of marriage and civil partnership to 18, provisions will also be introduced so a marriage solemnized anywhere in the world after the date of the coming into force of the law is void if, at the time of its solemnization, at least one of the parties to the marriage is domiciled in Jersey, and at least one of the parties to the marriage is under the age of 18. It is important to note that if a couple who are not domiciled in Jersey marry under the age of 18, in a jurisdiction that still lawfully permits it, and then move to Jersey, their marriage will be recognized. The second item is about open-air locations. In February 2018, this Assembly debated and voted in favor of allowing the solemnization of marriage in the open air, including in public spaces. Open-air weddings have proven to be popular, but bring practical challenges in the case of inclement weather. The draft law proposes to introduce amendments that would permit a couple to also choose an alternative non-open-air approved location at which their marriage could be solemnized in addition to an open-air location. The amended law will require the application forms and published notice of a marriage to contain both locations. The couple must choose which approved location of the two they wish to have their marriage solemnized at prior to the issuing of the marriage schedule. The third item is the registration of names and the provision to prohibit confusing, embarrassing, or offensive names. The legislative provisions that provide for the naming of a child can be found in the 2001 law. The law provides that where a birth has occurred, it is the duty of an informant to inform the Superintendent Registrar of the particulars of the birth within 21 days of the birth. The law currently explicitly permits the birth of a child to be registered without that child being given a name. The article also permits a child's name to be altered up to a year after birth, such as for a baptism. The law does not currently require that a child be given a name within that year, and more importantly, there is no mechanism in the current law to require a nameless child to be given a name at all. As a result, the law is currently in direct conflict with Articles 7 and 8 of the UNCRC. Article 7 of the UNCRC requires that the child has a right from birth to a name, and Article 8 of the UNCRC requires state parties to undertake to respect the right of the child to preserve his or her identity, including nationality, name and family relations, as recognized by law. The draft law will insert new provisions that would shorten the statutory period where a child can be registered without a name from 1 year to 3 months. However, the ability to alter a child's name for up to a year would remain. If a child remains nameless after 3 months, the Superintendent Registrar would be required to notify a person with parental responsibility that they have a further month to provide a name for the child. If the child remains nameless, the Minister for Home Affairs shall choose a forename for the child. Legislative provisions to limit names that can be given to a child because they are confusing, offensive, or embarrassing are very common in other jurisdictions around the world. The draft law would insert provisions that prohibit confusing, embarrassing, or offensive names and permits the relevant registrar to register a birth without a name or to refuse to alter a name where that name might reasonably be expected to cause mistake or confusion or embarrassment to the child, is sought for an improper purpose, or is for any other reason objectionable. The draft law would require the Superintendent Registrar to be made aware of the decision, and if the decision was taken by a parish registrar, the Superintendent Registrar must confirm that decision. The draft law provides a route of appeal for an applicant. Appeals would be made to the Minister who, having regard to the interests of the child and the public interest, determines the appeal. The new provisions will certify Articles 3, 7 and 8 of the UNCRC, therefore improving the island's compliance with the treaty, and more importantly, it improves the outcomes of any children who are subject to them. Next is the transfer of relevant registration duties. A number of the proposed provisions within this draft law are concerned with the transfer of relevant registration duties. These have been developed in consultations with the Comité des Connétables. I would like to offer my thanks to the Comité des Connétables and the chair of the Comité des Connétables for their engagement, support, and scrutiny of these proposals to create a series of provisions that are acceptable to all parties. Article 42 of the current law provides for the Superintendent Registrar to act in the capacity of a parish registrar on a temporary basis, where there is no parish registrar appointed to that parish. The statutory responsibility and liability still remain with the parish registrar and the constable of the parish. This draft law will enable a connétable to choose to transfer registration duties of their parish to the Superintendent Registrar, or transfer registration duties back to the parish should they wish. These transfers will be subject to a statutory notice period that has already been agreed, and that notice period will be set out in an order. These provisions provide a choice to a constable, but prevent registrations being switched between a parish and a Superintendent Registrar frequently. Currently, the Superintendent Registrar is acting in capacity of a parish registrar for 10 out of the 12 parishes. It has been commented so far that these arrangements have been working well for the parishes involved. The next item is the abolition of a wife's domicile of dependence. Currently, The customary law of Jersey provides for a married woman to have a domicile of choice in death, but not in life. Amendments made to the probate law in 1998 provided for a wife to have a domicile independent to that of her husband when matters of movable estate are being considered. However, this is not possible while she is currently alive. The domicile of dependence for married women exists just as there is a domicile of dependence for children. This means that no matter what a woman's connection to Jersey is, no matter how intent she is to make her home in Jersey and to remain here permanently, if she is married to a man with a domicile elsewhere, she is unable to have a domicile of choice in Jersey. Equally, if a woman married to a Jersey man seeks a domicile of choice abroad, unless her husband also changes his domicile, she is stuck with the same domicile as her husband. She can only lose her dependent domicile by divorcing him. Our customary law also falls directly foul of Article 15.4 of the Convention on the Elimination of Discrimination Against Women, which provides, state parties shall accord to men and women the same rights with regards to the law relating to the movements on persons and the freedom to choose their residence in domicile. Jersey law does not currently permit this. The draft law proposes to introduce provisions that would abolish the customary law so that a married woman could return her domicile of origin if it is different to her husband's, or seek a domicile of choice in the same way as an unmarried woman. Finally, there are administrative amendments which the draft law makes, most of which are purely administrative or are amendments intended to clarify the original intentions of the law. I present this to the Assembly.
Are the principles seconded?
They are, sir. Yes.
Does any member wish to speak on the principles? If no member wishes to speak on the principles, Connétable St Lawrence.
Thank you, sir. I rise again today to thank another member of the Assembly, this time the Home Affairs Minister, for his cooperation in the matter of the parish registrars. He just gave a detailed explanation of how the system will work, and the constables are extremely aware of how central government, when it undertakes reviews of laws in particular, can perhaps inadvertently remove some of the traditions and customs that are vital to the parish system. And certainly we as constables intended to ensure that the role of parish registrar would not be lost by being passed over on a permanent basis to the superintendent registrar, notwithstanding, as the Minister has said, that at the start of the pandemic, we did all place our registration duties with the superintendent registrar at that time. So what these amendments allow, or this law allows, is for a parish to give the registration duties or the registrar duties to the superintendent registrar to manage for a time that can be indefinite, but that when the constable is able to find a suitable person to act as parish registrar, the duties can be resumed by the parish with a period of notice, and that notice period has been agreed between the Comité and the Home Affairs Minister. So I thank him for the collaborative working, which is, of course, the way that the constables always work. Thank you, sir.
Very much, Connétable. Deputy Doublé.
Thank you, sir. As is mentioned in the Minister's report, P65 2015 was the original proposition lodged by myself, whereby States members instructed the Minister at the time to bring forward the legislation to allow legal humanist weddings, but also open-air marriages to take place. And at the time of that debate, I suggested that we should include a provision for couples to identify an alternate venue in case of inclement weather. So I'm delighted to see that this has been brought forward in the legislation today. because I know from couples who have recently married or who are planning to marry that the lack of this has sometimes put people off opting for their ideal outdoor wedding for fear that their day would be ruined if there was, say, a thunderstorm with no option to seek shelter. But I will take this opportunity, sir, to call again for further measures that are required to allow couples to fully access the benefits of this law. And despite the original law being passed 5 years ago, we still do not have a selection of outdoor locations on publicly owned land which are pre-registered so that couples can access them with ease and at minimal cost. So while it is wonderful that outdoor weddings are an option in theory and are going to be more accessible with this legislation today, couples are telling me that the process of registering, say, an area of local woodlands that is particularly special to them, is still very difficult to navigate and costly. A recent response to a question lodged by myself stated that the planned work to register a selection of sites across the island has been delayed by COVID, which, of course, I understand that work would have been put to one side. But I would urge the Minister to see that this is now being progressed. And it has also occurred to me, sir, that as well as land owned by the government or the states of Jersey, I'd wager that there are, in addition, many beautiful locations, outdoor locations, which may be on parish-owned land. And this is something that perhaps the constables might consider doing in order to give full effect to this part of the law. So I support that part of the law, and I also am grateful to see the parts that address children's rights and married women's domicile. And I thank the Minister for bringing forward the legislation today.
Thank you very much, Deputy. Deputy St Mary.
Thank you, sir. My question is a very specific one, and I apologise if the information is already there. I am one of those who had the luxury of two ceremonies on the occasion of my wedding. First was in a Catholic church, a private ceremony at St Auban, and the more public one was a blessing at Trinity Church later in the day. The legal solemnisation took place at the Catholic Church, and as the Catholic priest is not a registrar, or certainly was not then, the registrar of the parish was present to authenticate that. My concern is simply that if certain facilities or responsibilities are being removed or being voluntarily removed by the parochial registrars to the superintendent registrar, whether it will be possible in the future for someone who wishes to get married in a church other than Church of England Church will have the capacity to require, if not the registrar of that parish, because there won't be one, the superintendent registrar or perhaps a delegate to attend that wedding, so that they won't be inconvenienced or deprived of a wedding in the church of their choice. And perhaps the Deputy would, or Minister would clarify that in his summing up. Thanks, sir.
Thanks, Deputy. Does any other member wish to speak? Deputy of St Peter.
Yes, sir, thank you very much. This may be a little bit pernickety, but having two options, i.e. within 48 hours you have to determine which location you wish to have your marriage solemnised, either outdoor or an alternative indoor one. I'm not being over trivial, but I've lived in Jersey quite a long time, and 48-hour weather forecasts aren't exactly that accurate. So I'm just wondering what the rationale is and why we can't wait until almost the morning to make that final decision. I know the practicalities of guests is to be brought into consideration, but the actual practicalities, the actual decision of where you wish to solemnise your wedding. It's a bit pernickety, but thank you, sir.
Does any other member wish to speak on the principles? Tabas and Brillard.
Thank you, sir. And following on from my colleague from St Peter's, there is an issue with exactly the point he makes, in that if a hotel on a beachside position wishes to arrange a wedding on a beach, they can't at the last minute move it inside. And this is an issue in the light of, as my friend mentioned, the weather in the island. And could I ask the Minister for Home Affairs to address that matter in his summing up? Thank you, sir.
Does any other member wish to speak on the principles? If no other member wishes to speak on the principles, then I close the debate and call upon the Minister to respond.
Sir, I would like to thank the Chef de Connétable for the excellent work that we've done together. It was very collaborative, and we came to a very simple arrangement which satisfies both parties. To Deputy Doublet, well, I thank her for having brought this forward because I think it is really, really useful for Jersey. And I think that, of course, COVID has just slowed down the registration of public places, and this will accelerate soon enough. I will certainly make sure that it happens. There are quite a number of locations in Jersey that would be really suitable. To the Deputy of St. Mary, the Superintendent Register will attend in church, and I understand that they would have had to do so even when we had the parish registers, so nothing has changed in that respect. To Deputy Hewlin and Constable Jackson, the Constable of St. Brelard, this actually is an extraordinary question. The reason why you have to warn in advance of where your marriage will take place. And this comes down to the most ancient roots of the performance of a marriage, which has to be witnessed by your community. So right now we sign documents and there's an official registration, but basically the marriage itself must be announced to the community, who can then be a witness to it. And that's why, as much in church or in any other location, the announcement, the public announcement, must be made in advance. So if it's going to be in an open space, there might be weather considerations, which means you might need a backup location very quickly, but we still want to warn the community of where this is going to take place within 48 hours so that they can attend, because traditionally it is the community that witnesses the marriage. With this, I maintain the proposition, please.
Well, I invite members to return to their seats. The vote is on the principles for this law, and I ask the greffier to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The principles have been adopted. 43 votes pour, no votes contre, no abstentions. Deputy Ward, does your panel wish to call the matter in?
No, thank you, sir.
How do you wish to deal with the matter in second reading, Minister?
Sir, on block, please. The two laws gather 153 amendments, and I'm pretty sure the Assembly doesn't want me to read them all. But I would like to take advantage of this to thank Scrutiny for the excellent report on those two pieces of legislation.
So you're wishing to take the, effectively propose all of the amendments en bloc, and anyone that wishes to ask any questions of you can do so?
Absolutely, yes, please. Sir.
Very well. Is it seconded?
Yes, it is, sir.
Very well. Does any member have anything? Deputy Morell.
Thank you. Yes, sir. My questions are about the naming. Names have always been of interest to me. And I'm particularly interested in the Minister's power to name children, and also the prohibition against confusing names. And I'm really interested in understanding the Minister's how is the Minister's process going to be in this? So if the Minister, and I appreciate it's going to be a rare occasion, or I should hope it's going to be a rare occasion, but if the Minister is in a position where he has to find a name, choose a name for a child, could he enlighten us as to how he will do that? Will he take cultural considerations into account? Will he have a list? Will the list be two names, John and Jane? You know, something as bland, nothing wrong with the names John and Jane, but extremely regular names, let's say. Or will he take other factors into account? Because obviously, from a cultural perspective, this could have quite an impact on the child. Similarly, I'm confused about the element of confusing names, because is this superintendent registrar going to be in a position where, because the superintendent registrar doesn't understand the name, because perhaps it comes from another culture and another language, that they would be able to refuse such a name purely because they don't understand it, not because it is, even though it may be a perfectly regular name in another culture. So, and this is why I don't know my position with the en bloc situation, sir, because I would have asked for these particular articles, Article 50, and they're to be voted on separately, because
you're entitled to do that.
Am I,
for
sir?
legislation, any member can ask for articles to be taken separately.
Okay, so I will keep that under consideration. Thank you. Dependent on the Minister's answers, because is Article 50, and the ones following that with regard to registration of names. So yes, sir, I would really like the Minister's answers as to that, because I think the Minister's going to be in a very, very difficult position here. So whilst I appreciate it is a human right to have a name, and in the worst of all situations, if parents are refusing to give a name, how do we ensure a name is given? That power falls to the Minister. I understand that logic, but I need reassurance about the processes as to how the Minister will do this. Will there be a civil service list of approved names, for instance, that he will choose from? Will the Minister visit the child to try and understand some of the individuality of the child? Because this will take place after 6, 7 or 8 months old. There will be a great deal of individuality about that child at that age. So yes, sir, I really would like answers to this from the Minister. Thank you, sir.
Thank you, sir. And pursuing the point I made in the principles, I'd ask the Minister in Article 13 if you can just expand a bit on his comments you made with regard to the 14-day notice period. It seems to me Article 13, actually there can be an alternative site prescribed in the document. What I'd like to understand is whether, shall we say, in a property next to a beach, whether the principal, the primary location can be the beach, and the fallback, the adjacent hotel, if possible, because it seems to me that it may be the case. Could he expand on that? Thank you, sir.
Does any other member wish to speak on any of the draft articles in second reading? No other member wishes to speak? Then I close the debate and call upon the Minister to respond.
So the question of Deputy Moyle is also fascinating, and it is one that elicited lots of discussion. When anything is given to the Minister, of course, we're not really talking about the person, but their whole team. So in that circumstance, there would be guidance issued. First of all, there would be guidance issued by the superintendent registrar, but also that would be probably a collegial decision based on carers for the child, if there are carers, based on all possible circumstances. I cannot imagine any minister in that position do like we used to do in France, grab the calendar and say, born on that day, that's the saint and that's the name that you're getting. That is over. So there will be sensibility. And of course, there is always a route for appeal and a way for the parents to rename the child if they want to. So it is actually quite open. But we had to write, we have no other choice but to write down an ultimate responsibility in the law. In terms of switching from location to location, yes, we have had problems because actually some of the locations quite typically are beaches in front of hotels. But not only there is the tradition, that means that people must be aware of where a wedding is taking place. There's also the defense of sham marriages, where we want to be able to supervise a marriage and make sure that it is really properly happening. So that's why the 48 hours is in law. Having said that, I would like to propose all the articles up to 49.
Up to 39?
49. I think Deputy Morel wants to separate 50 and 51.
Is that still your wish, Deputy?
No, I'll happily go on block.
Very well. There's no need
I
to
would
take
like to have them on block, so please.
Then you'll just deal with all of them together then. Very well. Very well. The vote is on the articles in second reading, and I invite members to return to their seats, and I ask the greffier to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The articles are adopted in second reading, 46 votes pour, no votes contre, no abstention. Do you deal with the articles in third reading, Minister?
Yes, please, sir.
Are they seconded for third reading?
Yes, sir.
Yeah. Sorry, did I...
Just a very quick thanks to all the officers that have participated in this work that has taken 4 years and 153 amendments. Thank you, sir.
Yeah. So they are seconded for third reading. Does any member wish to speak in third reading? No member wishes to speak in third reading. Deputy Tadier.
Thanks, sir. You'll stop me if you think my comments are not appropriate, sir, but I didn't think it was appropriate to speak earlier because the comments are more of a philosophical nature and is to do with the. I think that a lot of the changes here are sensible and necessary, and it is constantly necessary to review our laws. But I do have some comments about what we're left with in the sense that the...
Well, Deputy, you did invite me to interrupt you if I thought it was going to be inappropriate, and although I don't accept that invitation readily, can I just remind you of the standing order which says that the limits of the debate in third reading are the adoption or non-adoption of the law as passed in second reading. In other words, there is no room for a further discursive exercise or philosophical musing, if that is the direction you were going in, your argument should be, should the law be adopted or not adopted?
Thank you, sir. In that case, I could tell the vast majority of what I was going to say and look at whether or not we should adopt it in the third reading. I would simply say that I can adopt this on the basis that I think overall it's going in the right direction, but I do have serious concerns about the balance of rights and responsibilities when it comes to who is able to perform marriages. And I would simply say that from what's in the law, I still have concerns, which mean that I can't adopt this wholeheartedly, because I think, for me, that ultimately marriage is something that the state confers on a couple, and when we delegate responsibility for marriage onto other authorised parties, who are then allowed to discriminate on the spouse who can and can't get married, and we put in clauses to protect them because they have certain belief systems, that is problematic for me, sir. So I am supporting this in the third reading with that caveat in place.
Thank you very much. Deputies, any other member wish to speak in third reading? Conetapa St Prahlad.
Sir, thank you. And I've just taken this opportunity to thank the parish registrars still in place for the assiduity of their duties, which is in a changing world, and they've had to adapt to the proposed changes which we're seeing today. And I thank them for their efforts and time. Thank you, sir.
Indeed. Does any other member wish to speak in third reading? No other member wishes to speak in third reading? Then I close the debate and call upon the Minister to respond.
Thank you, sir. I think I understand Deputy Tazier's philosophical issues. Marriage is something that is conferred by the states through registration. However, if individuals want to go through the church of their choice or any other system, they are welcome to do so. So I think that now, and as we go on expanding with these laws, we're making this more open, more available, and less discriminatory. So I think we are really moving forward with this. And with this, I would like to recommend the law in third reading to the Assembly.
Very well. I invite members to return to their seats and ask the greffier to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The law has been adopted in third reading, 45 votes pour, no votes contre, no abstentions. Very well. We come on next to the draft civil partnership amendment Jersey law lodged by the same minister. And again, the main respondent is the chair of the Children Education Home Affairs Scrutiny Panel. And I ask the greffier to read the citation.
Draft Civil Partnership Amendment Jersey Law 2000, a law to amend the Civil Partnership Jersey Law 2012 to provide for opposite-sex civil partnerships and to amend the formalities and registration requirements for civil partnerships and to make consequential amendments to other enactments. The states, subject to the sanction of Her Most Excellent Majesty and Council, have adopted the following law.
Minister.
It will sound like I'm repeating myself a lot, but basically what we have done is to match marriage and civil partnership as much as we could, so that they are now almost completely similar. This draft law before you will make a number of significant improvements to the civil partnership process in Jersey. None of these amendments will change the legal rights and responsibilities of persons already in a civil partnership. If these proposals are adopted, opposite-sex civil partnerships will be introduced. The minimum age of civil partnership will be raised to 18. The entry process for civil partnership will be changed so it is safer and much more robust. This draft law makes amendments to extend civil partnerships to all. It enables, in addition to same-sex couples, all other couples to form civil partnerships. There are three key drivers for making this change. The first is the public desire for civil partnerships to be available to all. Two separate public consultations have been undertaken 4 years apart. Both asked the public if they agreed that civil partnership should be available to all. In 2014, 72% of respondents agreed that civil partnership should be available to all, and in 2018, 78% agreed. The 2018 consultation also asked if Jersey should stop providing for civil partnerships, and 68% of all respondents disagreed. It was made clear in the consultation responses that civil partnerships offer an alternative to marriage that is free from the traditions and perceived patriarchy of marriage. Although extending civil partnerships to all was discussed at the time of the 2018 reforms to the marriage law, it was accepted that the civil partnership law should remain unaltered until there was a further court-related ruling. That court ruling was made in June 2018, when the Supreme Court ruled that the Civil Partnerships Act of England and Wales was discriminatory in that only same-sex couples can contract a civil partnership, excluding opposite-sex couples. England and Wales subsequently introduced regulations that enabled civil partnerships to be extended to all in 2019. The Supreme Court ruling, also based on the Civil Partnership Act, could easily be construed to Jersey's civil partnership law, where the same discrimination still exists. We have also experienced opposite-sex civil partners who have formed the civil partnerships in England or Wales, moving to Jersey. Our law currently does not recognize the civil partnerships, and as such, the non-recognition of those persons' civil partnerships causes them significant uncertainty. The draft law also provides for couples to convert their existing marriage to a civil partnership, should both parties wish to do so. This is similar to provisions that were introduced as part of the same-sex marriage law amendments in 2018. The aim of conversion is allowing a couple to convert their union to one that was previously denied to them. In line with amendments made by the Marriage and Civil Status, Amendment Number 5, Jersey Law, the draft law will also raise the minimum age of entry into civil partnerships to 18 years of age. This is to ensure that the minimum entry age for both unions remain the same. It makes no sense for them to be different. The obligations that this island has to the UNCRC and CEDAW apply equally to civil partnerships as they do marriage. The comments made by these, The comments made by the UNCRC and CEDAW are therefore equally valid. And it is right that we also raise our minimum age of civil partnership. In February 2018, a commitment was made during the debate on the then draft Marriage and Civil Status Amendment Number 4 Jersey Law that over the following months, the government would bring forward proposed changes to the civil partnerships legislation so that processes for applying for and registering civil partnerships became the same as the processes for marriage. Amendments made by this draft law will make it easier for people to apply for a civil partnership, and most importantly, we will have a law that provides better safeguards against sham and forced civil partnerships. Today in Jersey, it is possible for a person to apply for a civil partnership and organize a civil partnership ceremony without the knowledge or consent of their partner. A partner may know nothing about the intended civil partnership until the very point at which they are standing in front of the civil partnership celebrant and are asked to make legally binding vows. A surprise civil partnership ceremony could be a highly coercive situation. For example, a woman or a man forced into civil partnership because they feel unable to say no in front of family or friends at a civil partnership ceremony they knew nothing about. Such civil partnerships will not be allowed to take place under the amended law, which introduces a range of safeguards against sham and forced civil partnerships. It will essentially update the civil partnership process to mirror that of marriage. Like the current marriage law, both parties to the civil partnership will have to give notice. They will both have to sign the declaration stating that they are free to form the civil partnership. Both will need to present themselves to the superintendent registrar and complete a signature verifier form. The civil partnership celebrants can then confirm that the two people standing in front of them are the same two people that have been given permission to form a civil partnership by the superintendent registrar. This is a significant improvement because at the moment it is simply not known if the couple presenting themselves at the civil partnership ceremony are the same two people whose passports or visas or supporting identity documents were inspected by the superintendent registrar. Under the amended law, any non-resident who wishes to form a civil partnership in Jersey will need to provide a certificate of no impediment to civil partnerships or its equivalent. No one will be able to give notice to form a civil partnership in Jersey unless the superintendent registrar is satisfied that they are free to enter into civil partnerships. This is the same as the current marriage process. Once notice is given, it must be in the public domain, which will include publication online for at least 25 clear days before the date of civil partnership, providing greater opportunities to identify potential sham civil partnerships. The amended law makes it easier for couples to give notice to form a civil partnership and to have their civil partnership registered. Couples can apply and give notice online and are only required to visit the office of the superintendent registrar once before the civil partnership ceremony. This amended law also makes amendments to provisions for civil partnerships in emergency or special circumstances and bring them into line for the current emergency or special circumstances provisions for marriage. Currently, emergency or special circumstances civil partnerships are not possible. Such emergencies are when there is a risk of death, where a person is housebound, or where a person may need urgent medical treatment. Under the amended law, civil partnerships will be carried out by civil celebrants. These are individuals who are authorized by the superintendent registrar after taking an oath before the royal court, or by the superintendent registrar. All of the amendments to the process to form a civil partnership mirror the process already in place for entering a marriage. This is to reflect that in Jersey, the two unions are legally the same, with the same rights and responsibilities. It therefore no longer makes any sense to have a civil partnership that lacks the robust process and safeguards that are present in the marriage process. A new fee structure is also proposed as part of this draft law. The fees for a civil partnership will mirror those of marriage to reflect the identical work that will be required to administer civil partnerships. And with this, I present the law to the Assembly.
Thank you very much, Minister. Are the principals seconded?
Yes, they are, sir.
Deputy Tadier.
Thank you, sir. This is probably the time to be slightly more philosophical, sir, when we're debating the principles. And this is a reflection about where we've come and how we've got to this point. And for some, it will seem to have taken a very long time. For others, they'll look back and say, well, what a lot of change has happened in such a short space of time. And I think both of those points are true. I remember a younger then Deputy Mezek being in this Assembly, and he wasted no time following his by-election, following up on one of his, I think it was one of his key pledges around same-sex marriage. And there was a debate back then, it must have been in 2013, 2014, he'll know better than me, about equal marriage. And what we had at the time was so many spurious arguments coming from some members of the Assembly and some sections of society. We said, oh, we couldn't possibly let same-sex couples get married, all sorts of objections. And sure enough, there were obstructive amendments that were put into the proposition of Deputy Meslet at the time, and it didn't succeed in the form that it should have. And this led to Jersey's first ever true gay pride happening, which was an act of protest, not the act of celebration that it quite rightly has become today. And those were the roots of Jersey Pride. It wasn't a corporate sponsorship event, it was an uprising of the community, not just those who would be directly affected themselves, those who might have wanted to seek a same-sex partnership, indeed a same-sex marriage, full marriage that is, not what was offered to them in the first instance. And it was the sympathisers and supporters who saw the inherent injustice. And what's happened now is a great example of, I think, mission creep and unintended consequences. Because, of course, like I said, full marriage was never offered to these people. It was civil partnerships in the first instance back in the day. And I remember a very strange scrutiny hearing where I was on the scrutiny side and Senator Rosa was on the government side, explaining how civil partnerships were not the same as marriage. And I remember it was a public hearing, and I remember distinctly asking, well, why don't we just allow same-sex couples to get married? You know, because what we have here isn't the same. He says, well, and he was also saying civil partnerships are not marriage. We have to be very clear about this. And I don't want to use the term maybe incorrectly, but there was something Thatcher-esque about it, or certainly something quite absurd in the sense that we didn't seem to know what we were doing there. I think we were arguing on the same side, but not knowing, in fully understanding what the other was saying. And I was saying, that's the whole point. It isn't marriage, is it? Why are we not offering marriage to these people? And of course, what we had is we created this vehicle, if you like, which stopped short of full equality because we couldn't bring ourselves, or the majority at the time couldn't bring themselves to allow same-sex couples to get married, even though the overwhelming support of the public, whenever surveys had been done, and certainly anecdotally in Jersey, the argument was still the same, the support was there. So what we've got now is we've inherited this vehicle called civil partnerships, which used to only be reserved for same-sex couples. And it was created, not as what is being proposed now, it was created because that was the only alternative for same-sex couples to enter into a similar union to other people. And it wasn't created because there was a few people in society who, and I can sympathise to a certain extent, who had this philosophical issue that marriage is some kind of patriarchal construct. So when it was dreamt up, it wasn't to give an alternative to marriage because some people might think it's patriarchal. Incidentally, as a little footnote, it's entirely possible to enter into marriage and not find it a patriarchal construct. Because that obviously all relationships are unique and individual. So I don't accept that premise. But now it's being sold to us as, oh, we better do this. First of all, because people want it. We've asked them what we should do with civil partnerships. And secondly, because there's a patriarchal issue with same-sex marriage. But I'm afraid that doesn't really stack up. Because first of all, that's not why we were sold it. And the logical thing to do, despite what the public might say when they're asked a certain question, and of course if you ask the question, should we extend civil partnerships to everyone, you're going to say, yeah, they should be open to everyone. But really, we shouldn't have ever been in the position of creating civil partnerships, because we should have simply allowed marriage to be accessed by everybody in the community, irrespective of their sexuality or who their loved one was. And this isn't what we've done, sir. So we have this kind of irony whereby we've now, I would say we've now got three types of marriage. We've got religious marriage, which can only be performed between a man and a woman. And we've got civil marriage, so state marriage, if you like, which can be entered into by anybody, whether they're male or female, or same-sex or not same-sex. And then we have this civil partnership, which is going to be another alternative. And so we've actually created much more bureaucracy. And although I'm on the left of Jersey politics, I'm actually in the centre of politics, in the global sense of it, I think, more and more. But in Jersey, I'm probably on the left, and we're often accused of introducing red tape, etc., and wanting unnecessary legislation. For the record, I'm more of a libertarian, sir, and I have a problem with any legislation that can't be justified. And what I've seen here is how we've accidentally created this new vehicle, and we're perpetuating it, whereas this vehicle, sir, should just be taken off the road. We should be saying that for those people who have a civil partnership, that's great, you can keep it. If you want to convert it to marriage, you can also do that. But we're not going to be entering anybody else into new civil partnerships from now on, because they've served their purpose. And now we have certainly a much more equal system. Anyone can get married. You don't need civil partnerships anymore. But to hear people who philosophically would have been opposing same-sex marriage back in the day, now arguing that marriage is a patriarchal construct, and to allow for a few people who think that it's a patriarchal construct, we're going to not just continue but actually extend this vehicle is, I think, quite frankly bizarre. Now, sir, I'm wrestling as to whether or not it's sufficient grounds to vote against either all of this or this part, because I think there is a good argument for it. But where does it stop? I mean, what if somebody has a problem with marriage because it's patriarchal, but they also have a problem with civil partnerships because that smacks too much of the state, and it has a certain strangeness about it that they don't like, and they want a different kind of union. It could be like the French system, the Pax system, whereby it's much more liberal. If that still exists, it's been a few years since I studied French sociology, so in fact, it's only at the time two relatives could decide to enter into a union. It wouldn't be like marriage, but it would be by and large for social and tax purposes, so that their living arrangements could be recognised by the state. Are we going to have further forms of union that are recognised simply because some people in our society think that there's a certain problem with what already exists? So I wanted to flag that up, that when the ultra-conservatives were actually resisting extending marriage rights for the wider community, what they've actually done is ended up potentially, in their minds, undermining marriage, because they've created a very fractured way of people entering into something which has been described as very similar, I think very much the same as marriage, to the point where they're interchangeable. You can say, I want to convert my civil partnership to marriage, I want to convert my marriage to a civil partnership. You can only do that once, you can't keep doing it quite sensibly. That they're completely interchangeable. And I think the point is we should have just said marriage is equal for everybody. And at this point, logically, I would say let's just get rid of civil partnerships, let them fizzle out. Not the individual relationships, may they long continue to be strong, but we don't need to be getting involved in this extra red tape as a government. And think of all the manpower, all the headaches that Deputy Guida and the officers have had with this unnecessary law, just because back in the day the ultra-conservatives couldn't be bothered to do things properly, sir. So I'll leave those comments there. I do have specific concerns about the transgender questions that will be asked, and I think that was more so in the marriage law, sir, but I think the two very much go hand in hand. And I still put on record that we don't have full equality when we, this is the point I was trying to make earlier, whether it's civil partnerships or marriage, I believe that it is ultimately the state that confers the right of marriage and of the ability to perform marriages on people, whether we like that or not. And there will be people, of course, who argue, well, the church was doing it long before the state used to do it. But of course, back then, the church was the state. And even before the church, these things were done perhaps on a much smaller scale, ceremonially, even sometimes just with the agreement of the two individuals. And I do have concerns that when we give institutions other than the state the right to perform legal marriage, that we should be putting on them an obligation to perform marriages or civil partnerships in an equal way, in the same way that we would expect of the state to do it. I'll leave those comments there, sir, because I do want to try and keep them relevant to what we're debating. But I'd be interested to see and hear what the comments are from the Minister. I know he's a very thoughtful individual. And also whether there's going to be any resistance from the traditionalists in the Assembly and whether they see this as somehow undermining traditional marriage. Perhaps it doesn't undermine it this close to an election, sir. Thank you.
Deputy Dublet.
Thank you, sir. The Minister mentioned consultations that have been done on our marriage laws. And I recall in 2014, when I was first elected, and those who are part of the previous Assembly will recall this, that there were calls from the public at the time to extend civil partnerships to all couples. And I do think it's disappointing that we decided to wait and see what the UK did, because I think it was clear in 2014 that this was the right thing to do. It was clear to me then, it's clear to me now. And I think that as the States Assembly, I think we should be deciding what's right for Jersey. And in future, if we do think it's the right thing to do, we should bring that forwards ourselves and not wait for the UK. But I'm pleased that we have eventually got here today, and it's a really important step for equality. And previous speakers have spoken about the decision to extend marriage to same-sex couples, and I absolutely applaud the work that was done by Senator Mezek. And I remember attending that the first Pride Parade and speaking at that parade in my capacity as a union representative when I was a teacher, and it was an absolutely wonderful moment of islanders coming together, the LGBTQ+ community and allies coming together, and showing how important something really was. So I thank the Senator and his colleagues for organising that. And at that time, so it was becoming clear to us that, and again, Deputy Tadia has referenced this, that although the technical details of the marriage law and civil partnership law may have been the same or similar, and they're not the same actually, because we know they're not the same because of, for example, the tax issue that we have with married women not owning their own tax affairs, whereas in civil partnerships it's partner A and partner B. So there are differences. But nevertheless, the reasoning given for extending marriage to same-sex couples was not a technical one or a legal one, it was a cultural one. And again, Deputy Tadia has referenced this. It is the cultural significance behind being able to say, this is my wife, this is my husband, and the meaning and the weight that those terms have for people and people wanting to be a part of that institution, which is so important to us. But in the same way, there are many mixed-sex couples who, because of their interpretation of the meaning behind the institution of marriage, as Deputy Tadia has referenced, and its historical connotations of women being given away or wives obeying husbands, and again, Deputy Tadia said that's certainly not a part of most marriages today. But nevertheless, there are many couples, young couples especially, who do feel strongly about this and do not want to be a part of it, but they still want to have some legal protection and recognition of their union. And I do think it's unfortunate that Deputy Tadia is tempted to dismiss these beliefs. because dismissing those deeply held beliefs, I think we should not do that. I think we should acknowledge those beliefs and respect them, because they are deeply held by many people. And people who hold those beliefs, who do not want to opt into marriage, are currently not able to access certain rights and privileges. So I would urge the Deputy to show that he acknowledges that and to vote for this legislation in recognition of that. Because actually I think there is a misconception, and the Minister may have touched on this, there is a misconception that there is something called a common law husband and wife arrangement. I think many people in Jersey who are unmarried and cohabiting believe that after a certain number of years, or if you own a house together, etc., that you're a common law husband and wife. And this is actually a myth. And I know this has been raised by members of the legal profession campaigning for mixed-sex civil partnerships. It is a myth. So couples who are currently cohabiting for any number of years do not have access to those rights and privileges afforded by the state to those who are married. And I would urge couples who are currently cohabitees and who don't want to opt into marriage, I would urge them to take advantage of this excellent new piece of legislation, which I hope we're going to approve today, and to opt into a civil partnership instead. Now, so members will note that I have used the term mixed-sex couples, which differs from the terminology used in the law in front of us today. And I think it's fair to say that the Children Education and Home Affairs Scrutiny Panel, of which I'm Vice Chair, we did consider this, and we considered amending this because we deem the term opposite sex to be problematic for reasons which I will outline. But we didn't want to hold up this legislation because it is an extremely important piece of legislation. But I think it's fair to say that the panel feels that this should be looked at in the future. And the reason for our concern being, so we're more aware now in 2022 that neither sex nor gender are binary. And by using the term opposite sex, we are reinforcing those binary misconceptions and erasing the identity of intersex and non-binary islanders. And so I want to apologise to those individuals for that, and again reiterate that it should be addressed as soon as possible. But that flaw notwithstanding, I think on the whole this is an excellent piece of legislation, which I personally have been waiting years to see it come to fruition, and I am very grateful that the Minister has brought it forward today. I think it will be extremely popular with islanders, and I hope that we can support this today.
Thank you, Deputy. Deputy Young.
Thank you, sir. I'm prompted by Deputy Tellier. I was quite taken aback by Deputy Tellier's comments. His comments are all often very philosophical and deep, and have contained some real gems of wisdom. But on this occasion, I fear he's not got the point. There are numerous practical reasons why people in society that don't want to engage in a marriage need and should have the right to be able to join their affairs together in a way which doesn't deprive them of all those so many things in law which they probably think, many of them, as Deputy Dubler said, they enjoy. They don't. And the track record of people suffering for that, not having such a facility, I think has been seriously remiss that we've delayed in doing this. And of course, France has had this for years. And I remember when the previous legislation came, when we brought in civil partnership legislation, I was really disappointed that we didn't allow couples, and I personally use the phrase of different sex, but I do understand the point that Deputy Dubler is making. But for me, the ability of couples to be able to have that alternative is absolutely fundamental point. I'll just give a couple of practical examples, and I'd like Deputy Tellier to think about it. For example, many people in these days in later life, they may want to engage in new relationships, having lost a loved one after very long marriages and become widowed or a widower, and somehow or other and brought up families and children, but obviously in those later years, they do want to have partnerships with another person. And I could, in those circumstances, I think it's highly likely that they may wish to opt for a civil partnership, which gives them all of the legal rights that they would enjoy in marriage. But, as it were, and there's also the issues of managing the relationships with families, with children, and a whole, extended families in that situation, where, as an option, I think it's been very poor that this has not been provided before. I was very, very pleased to hear this is coming forward. It's a shame that it took court action in the UK to both change it in the UK. And having worked for a law firm myself, I absolutely know there are numerous issues that arise where people are, their affairs are practically intertwined, but they're not legally, they don't have the legal status. It's appalling. Things like pensions, I won't bore the Assembly with all the catastrophic situations arise for people's purposes. So I am absolutely behind this. I'm very, very pleased it's been brought forward. That's what I wanted to put on the record, so thank you.
Thank you very much, Deputies. Any other member wish to speak on the principles? No other member wishes to speak on the principles? Then I close the debate and call upon the Minister to respond.
Thank you, sir. I'll respond to Deputy Tadier, Deputy Doublet, and Deputy Young's comments all together, because I think they all raised the same issues. Very quickly, the problem with religious marriage stems from Article 9 of the ECHR, which actually balances the rights of people with the rights of religious organizations. And I think it's, in a purely intellectual sense, it's easier to understand if you start from the point that there are between 6,000 and 7,000 recognized religions in the world. So our narrow view of what constitutes a marriage within one religion is actually an extremely, extremely small subset of that. And of course, the law and the human rights must deal with that. In terms of narrowing the scope and just calling everything a marriage, actually, I would personally be tempted to expand it. I think that it is good that we have a marriage that now is open to all. I think it's very good that we have civil partnership that is open to all. And actually, as an aside, we removed words from the original civil partnership law so that now it becomes a union between two persons. And that is it. There is absolutely no definition of what those persons are going to be. And I think that's exactly how it should be and how we should keep it. So this really offers quite a few tools to people. I would love to see a system like the French PACS installed in Jersey. I think we do need an association of persons that isn't a marriage, that isn't a civil partnership, that is much simpler, but still gives them some legal rights. Indeed, some people who've lived together forever might think that upon the death of one, the other can stay in the house, which might not be the case. The children of one might inherit, and the person that lived there their whole life might have absolutely no rights to the place they live in. So people must be careful about those rights, and it would make sense to have a third system that is a little bit lighter, that doesn't bring all the duties of the marriage, and indeed that could even be allowed for people of the same family. For example, two siblings who've just decided to live together for the next 20 years. So that's for another day. I think that's, I'm sorry, but that's about it. I hope I have covered everything. I apologize if I have left questions unanswered, and I propose the law in first reading.
Well, I invite members to return to their seats and ask the greffier to open the voting. The vote is on the adoption of the principles to the legislation. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. Too late. Okay, so that's 28 plus 12. The principles have been adopted. 40 votes pour, 1 vote contre, no abstentions.
Deputy Tadia voted contre.
Deputy Ward, does your panel wish to call the matter in?
No, thank you, sir.
How do you wish to deal with the articles in third reading, Minister?
En bloc, sir.
Very well. Are they seconded en bloc?
Yes, they are, sir.
Does any member wish to speak on any of the articles in second reading? Deputy Ward.
Thank you, sir. I may have put this at the wrong point of the debate. I wanted to do two things. One is I wanted to, at some point, and it's maybe here, to thank the officers in scrutiny for the work they've done on these reports, because we've had so many briefings, and to understand and the complexities and the subtleties of this is not easy. And I think they put together with the panel an excellent comments paper that has covered this, and we've got a real key understanding. So I would like to say to Deputy Doublé regards her explanation of the point of the panel. She explained it very, very well, and I'd like to thank her for that. That was mainly what I wanted to say, sir. It may not be at the right place, but I think that recognition needs to be made at times, because there are some huge pieces of legislation that come through, and they need to be filtered down to a usable form, and I hope the Assembly has recognised that as well. Thank you, sir.
Indeed. Does any other member wish to speak in second reading? No other member wishes to speak in second reading? I close the debate and call upon the Minister to respond.
Sir, yes, I would like to thank all the officers that were involved in writing these laws, and again, praise the work of the scrutiny panel. Also, now I understand better why this excellent report was produced, considering that some of their members were intimately linked to the genesis of all these laws. So yes, just to thank them all and propose the articles on block, please.
Very well. I invite members to return to their seats and ask the greffier to close the vote, open the voting. If members have had the opportunity of casting their votes, and I ask the greffier to close the voting. The articles have been adopted in second reading. 41 votes pour, 1 vote contre, No abstentions. Do you propose the articles in third reading, Minister?
Yes, please, sir.
Are they seconded for third reading?
They are, sir.
Does any member wish to speak in third reading? No member wishes to speak in third reading? I close the debate and ask the greffier to open the voting. Members have had the opportunity of casting their votes. Ask the greffier to close the voting. The law has been adopted in third reading, 41 votes pour, or 1 vote contre, no abstentions. I'm conscious of the fact that we're a little before the normal adjournment time, but would members wish to adjourn at this point before we start the next item of public business?
So I'm happy to propose that. Just before I do, members will be aware that I said that there may be legislative changes required for the sanctions as we move forward. There is indeed one, and subject to your approval, so it will be issued to members this afternoon. I will be seeking to take that regulatory amendment during the course of this state sitting, probably as the final item, sir. But I now call the lunch adjournment.
Very well. Very much. The Assembly then stands adjourned until 2:15.